Listen, before you sue anyone, before you hire a lawyer, before you spend a dime on litigation, you need to really understand something extremely fundamental that most people get wrong. Courts can only give you two things. That's it. Two things, and most entrepreneurs, they chase the wrong one. I'm Karam Nahas, the battle-tested lawyer, 20 years as an attorney and former litigator. That's how I know these things. And I spent 20 years in both courts that you're going to learn about today. I've seen what works and I've seen what's completely worthless. So in today's video, I'm going to explain to you the only two things that you can actually get in court and why most entrepreneurs get it completely wrong. So here's what most business owners think. They screwed me. They owe me money. I'm going to sue them and get my money back. That's how they think, and that's wrong. And that's how they plan. And that's how they build their contracts. If they even have contracts, and I'm betting they're not even good contracts. And it's completely backwards thinking. Court is a destination you never want to arrive at. It's danger zone 8. It's one of the biggest danger zones in business. It's expensive. It's slow. It's brutal. It's meant to be punitive. And most of the time, even when you win, you'll always lose. Trust me. But here's what 20 years of litigation taught me. The entrepreneurs who survive court aren't the ones who are chasing money. They're the ones who understood that there are only two kinds of courts, and they built everything, their contracts, their structure, their entire defense system to access the right court. That's key. That's what you have to really understand. So let me explain this to you. When you go to court, you're asking for relief. That's all you're asking for. You're asking the judge to do something to make your situation right. And there's only two kinds of things that the judge can do. Number one, in civil court, they can give you money, a money judgment. That's all that the court can do. They can order someone to pay you back, right? They can't take the money out of them. Now, court number two is chancery court, courts of equity. This is where you go to get power. The court can order someone to do something or order them to stop doing something. It's money or it's power. That's the whole game. So in civil court, it's only about money. In chancery or equity court, it's all about power. And that's what you really want. You want the power. And let me show you why. Let's talk about civil court, because this is where most entrepreneurs get destroyed. This is where they want to go. They want to go get paid. So you pay 30 grand, 50 grand, maybe even 100 grand in legal fees, and you win. So congratulations. The judge says defendant owes you $75,000. It's so ordered, right? And now you feel vindicated. Justice was served. And here's what nobody tells you. You're going to the courthouse to go get yourself money, but that judgment's just a piece of paper. It says that the debtor owes you money. Now, where are you going to go get that money? Getting a judgment and collecting on a judgment are two completely different things. There's no cash register in the courthouse for you. So to actually get paid, you got to start the collection process, garnish wages. If they're employed, put liens on property. If they own any assets that you can find, seize them. If you can find them, you do your due diligence. And here's the reality. Most people you'd sue don't have assets, or they've hidden them, or they've structured things to be judgment proof. I've seen it all day long. There's so many people out there who are judgment proof, or maybe they even file bankruptcy and your judgment gets wiped out. It's gone, discharged. You get nothing. Even with all that pain and suffering, all that money you spend, even the fact that the judge says that that money is yours, you get nothing. And that debt is discharged in bankruptcy unless it's fraud. And if the court finds fraud, that judgment can't be discharged in bankruptcy. Fraud is forever, and that's why I love it. I've collected on fraud judgments. Now think about it. If you have a dispute with one of your 5 enemies, clients who commit fraud, partners who betray you, if you can prove fraud, that judgment follows them. If you can't, judgment's kind of worthless. I'll be honest with you. I'll be the only lawyer to tell you that. They're worth the paper they're printed on. I've seen entrepreneurs spend 2 years winning a case, getting a 6-figure judgment, and collect zero, nothing. They won, but they still lost everything. And guess what? They paid me my fees. And that's what I mean when I say that even when I won, my clients lost. So things have to change. And that's civil court. That's chasing money. That's the trap that most business owners fall into because nobody taught them otherwise, right? Nobody taught them that there's another way to protect yourself smarter or more efficient because they don't have litigation attorneys advising them in their business like I do. So stay with me because what I'm about to show you next is the court that most entrepreneurs don't even know exists, and it's where you want to go to get power, to preserve power, to defend it, and to acquire power. Now, this is one of my favorite courts, chancery court, the court of equity. It's where a judge has total discretion. This is where the real power is. In chancery court, the judge has massive discretion. Like I told you, they're not just ordering someone to pay you money that could be worthless. They're ordering someone to stop doing something or to act, to perform, to hand something over. This isn't about collecting from someone who's broke. This is about using the court's authority to control the situation, to take power, to enforce a contract. Let me walk you through some of the most powerful tools in chancery court. Tools that I've used to go after business owners and tools that I've defended against. Number one, we have an injunction. An injunction is a court order that says to stop doing something, to stop infringing on my trademark, stop breaching the non-compete, stop using my trade secrets, stop contacting my confidential contacts. Now, a judge could also order you to start doing something, start performing under the contract, start returning your property, start fulfilling the conditions of a contract. That's specific performance. Now, if you violate an injunction, you're held in contempt of court, fines, there could be even jail. And here's what most entrepreneurs don't know, and it's something that's very valuable for them. You can get an injunction fast. I have. It's called a temporary restraining order. You go right into chancery court, you file an order to show cause. You got to show the judge that whatever harm you're getting is irreparable. You got to show them that you're likely to win on the merits and that the law's in your favor. And then a judge can shut down somebody's business tomorrow. One day they're running their business. Next day there's a court order that says they can't. And now they have to hire lawyers to defend that. That's real power. So what's number two? And I just alluded to this. That's specific performance. You had a deal, let's say. The other side backs out. Maybe it's a unique piece of property. It's a business acquisition. You really want that business. Now they're not performing on the contract. Maybe it's a partnership buyout. Money damages are not going to make you whole. You want that business. You wanted that deal. So the court can order specific performance. Like I said, force them to complete the transaction. Order them to perform an act. And I've defended against that in a car wash case that was such a mess. And the court ended up putting in a receiver. It became such a mess. But what the court can really do is order you to fulfill a contract, order you to take any sort of action, and it's extremely powerful. It's as powerful as creative that you can be on asking the judge what you want the judge to give you. You know what I mean? And if that contract's really bad for the other party, this could be extremely damaging, much more damaging than a money judgment. Number three is a constructive trust. That's when someone comes and sits inside something that belongs to you. A business partner took assets. An employee stole client relationships. Someone's holding property that they obtained wrongfully. Now, what does the court do? The court can impose what's called a constructive trust. And legally, what they're doing is they're holding that property for you, meaning you can't do anything with that property. They're freezing it. They're controlling it. They have power over your assets. So here's why that's powerful. If the other side goes bankrupt and the assets are in the constructive trust, they don't go to other creditors. They go to you. They've set it aside and it's been protected for you. That's an extremely powerful remedy when you have a situation when there's a bankruptcy. Power number four is a receivership. This is kind of a nuclear option. A receiver is when the court puts a third party, usually another lawyer, an accountant, or former judge, and they put them inside your business and they take control over everything. They access all your accounts, all your records, all your operations. They see everything. They make decisions. They sell assets. They shut things down. Now, you built this business, but now a stranger appointed by the court is running it. It's insane. Now, you ask for this receivership when you can convince the judge that the other side can't be trusted, that they might destroy evidence, spoliation it's called, or hide assets, or they're about to flee. Now, that's chancery court, and that's real power, and that's really extreme, but sometimes you need that in there to protect your assets. And if you're getting any value from this, hit the like button right now and drop a comment. Let me know if you've ever been to chancery court, if you understand the difference between civil court and chancery, how one court's just all about money, the other court's all about an action, preventing you from taking an act or forcing you to take an act, because that's the two biggest differences in any sort of civil court in America. Now, here's where it all comes together, and this is the strategic insight that separates entrepreneurs who survive from entrepreneurs who really get destroyed. And you can only get this from a litigation attorney who really understands what happens in court. Now, most business owners think about contracts as just paperwork, as something that says what you agreed to do. And that's not how I think. That's not how any battle-tested lawyer thinks at all. And you're going to realize that contracts are weapons. They should be your best friends. You should understand them, and they're tools that give you access to what? Chancery court, equitable relief. Forget about the money. When things go wrong, you want to go to chancery court, because here's the truth. You're legally exposed and you don't even know it. And at some point, you're going to have a legal issue with a client, a partner, a competitor, an employee. That these are your five enemies. We've gone over this in many videos. There's also your ego, and they're circling around you and they're always ready to strike. So when they do, when that day comes, what relief can you get? How fast can you get it? If all your contracts do is establish established someone owes you money, congratulations, you get a worthless judgment in court that you probably can't collect. But if your contracts are built to establish clear IP ownership, specific deliverables, fiduciary duties, confidentiality provisions, choice of law and equity courts, and equity-friendly jurisdictions that give you the relief that you need, now you have access to the right courts and a lot of power to get an injunction, to force specific performance, to impose a constructive trust, to get an accounting, to put a receiver in. You're not chasing money from someone who doesn't have it. You're using the court's power to control the situation and relief that most people aren't aware that's available. That's the defense. That's how you build a business that's actually protected. That's how defense wins championships. I know this because I've been in court. I've gotten that relief and I've reverse engineered it. And here's the thing most entrepreneurs miss. The threat of equitable relief is often more powerful than going to court at all. Because when someone knows you can freeze their assets, shut down their operations, have a receiver appointed, they negotiate differently, especially when they're going to have to pay your legal fees. You want that in the contract. So they're going to take you seriously. They settle. Now, a money judgment threat, they might just ignore you. What are you going to do? Chase them for years? Yeah, get a judgment against my LLC. I don't care. I don't have any money in it. But an injunction, that's immediate. That's real, and that's terrifying, and that could freeze your business tomorrow. And that's what you can get in a court of chancery if you really know what you're doing and you prepare yourself accordingly. So here's what I want you to do. I want you to stop thinking about contracts as paperwork. Start thinking about them as your access to power, to retaining power, defending power, getting power. Every contract you sign, every agreement you make, ask yourself, if this goes wrong, what relief do I want? Can I get an injunction, specific performance, a constructive trust? Yes, you have to think about all of this. It's not nuts. What provisions make that relief easier to get? This is how I think. And when you sit down with a lawyer to build your contracts, make sure it's a battle-tested lawyer, someone who's actually fought these contracts in court, not somebody who just drafts contracts, somebody who's an entrepreneur as well, understands business, not somebody who just pushes paperwork, someone who knows what holds up and what falls apart when the enemies come, a lawyer who's represented both sides of the table, a lawyer who's actually gotten injunctive relief. Structure your business for the day that you hope never comes. That's the key, because that's how you stay out of court. Business is war. And if you ever end up in court, that's how you win. By being prepared, by practicing proactive power. Now, courts can only give you two things: money or power. One is usually worthless. That's the money. The other protects your business, and nobody here really knew that, did you? Now, most entrepreneurs chase the wrong one. I don't want you to do that. They're legally exposed and they don't even know it, but I want you to make sure you're not. Now, this isn't to scare you. It's to help get you prepared so you don't get blindsided. So if you want to see where your contracts and your structure are vulnerable, where the gaps are across all 7 legal danger zones that you face, take my free risk report. It's literally 5 minutes. You'll see exactly where you're legally exposed and how to fix it. That's the most important thing. The link's in the description. And remember, defense wins championships. I'm Karam Nahas, the battle-tested lawyer. Your job is to get legally bulletproof.